A very good evening and welcome back to this special broadcast. The Supreme Court today commenced its hearing on CBI Director Alok Verma's plea against the CVC's decision to divest him of his powers and send him on temporary leave. Fali Nariman, Verma's counsel, argued that Central Vigilance Commission order removing Verma from active duty tantamounts to transfer and does not stand. He goes on to say, that the CVC's order on Verma's removal from active duty has no mention of consulting the selection panel. Remember, the selection panel, which comprises of the Prime Minister, the Leader of Opposition and the Chief Justice of India, is the only panel that can remove or transfer the CBI Director. That's at least the argument of the petitioners. The Chief Justice of India, meanwhile, has said that if it becomes necessary to take a note of the CVC report against Alok Verma, then, well, the government will have to submit its response to the same. The Supreme Court, for now, has adjourned the hearing to the 5th of December. A very good evening once again and welcome to the show. Joining us to discuss this CBI versus CBI battle further are Aishwarya Bhati, advocate at the Supreme Court, and Shantanu, the former Joint Director of the Central Bureau of Investigation. Ms. Bhati, let me come to you first. The question, of course, being discussed by the Apex Court is that for removing of the CBI Director, the consent or the nod of the selection panel is required. To which I asked the preliminary question, is this even a removal in the first place? Let's keep in mind, he hasn't been transferred. He hasn't been removed. It is more of a divestment from active duty. He's been asked to go on leave. So the question that I'm asking you is this tantamount to removal? Is this something that would have required the consent of the selection panel in the first place? Is this a removal, Ms. Bhati?
Well, so Ashmit, we know that what are the arguments that are being made in the Supreme Court. The learned attorney general is appearing for the government, and the learned attorney has taken it actually as a three-pronged approach, the way you are suggesting in your question. At first, they are saying that the government has intervened and, remove both the warring factions, which is number one, and number two, to ensure that the CBI continues to maintain sanctity and as an institution, so preserve the sanctity of the institution. On the question of this being removal itself, that again, the argument of the learned attorney general before the Supreme Court was that this really does not amount to any removal or transfer. He continues to be in the same house where he is, and it's not like he has been transferred or sent off somewhere else. But pending an investigation, which are obviously CBI is dealing with very serious issues. So when number one CBI and number two CBI, they raise questions at each other, they are bound to be very, very serious implications of that. And while the investigation is pending into it, it was absolutely imperative for number one and number two both to be out, to also maintain the sanctity of the investigation into that. And the third limb of the argument of the learned attorney is also that once the selection committee that recommends the name, it's the government who is the appointing authority, and the committee that is the selection committee becomes functus officio after recommending the name. So it is not an appointing authority in that sense that you have to go back to the appointing authority. It's just a selection committee whose role is to recommend the right name to the government.
That's an interesting point that you raise. I was about to raise it a bit later about the distinction between selection and the appointment. But now, since you have raised it, Ms. Bhati, let me take that issue up with Mr. Sen. Mr. Sen, your quick thoughts. The government's rationale is quite simple here. They're saying that the selection panel does what the name suggests, which is selection, which is vetting of the candidates in question. The actual appointing authority is the government itself. And by way of the government being the appointing authority under the Delhi Special Police Establishment Act, Section 4.2, they have the powers. Mr. Sen, do you concur with the attorney?
Yes, because let's compare this with other appointments. The collegium appoints the High Court judge. The UPSC appoints all civil servants. Now, they select and recommend. They don't appoint. They select and recommend. Collegium selects and recommends. Loosely, we say they are appointed by the UPSC. But the actual appointing authority is on UPSC recommendation is the government. And then government controls the transfers, postings, etc. It stands to reason that a person against whom serious charges have been made, and we have no doubt that here serious charges were made by number two against number one, and the number one made very serious charges and registered an FIR. Now, when they are under inquiry, it stands to reason that they should be moved out from position of authority, not transferred out, not thrown away somewhere else. They are still there, but they are subject to inquiry. I'll give you an example. Mr. Shukla of the Allahabad High Court is now being inquired into in that Prasad medical case. And he has been divested of all responsibilities. So if you compare these things, I think the act of the government in transferring them out and making inquiries during the period of transfer is absolutely correct. If the Supreme Court had not intervened, by this time the inquiry should have been over and government would have taken a decision. But because the matter is under challenge,
let me get a sense of what you're essentially saying. Mr. Sen, what you're essentially putting forth is that given that there were two warring factions, it's important to have both of them removed from this entire investigative process is concerned. But I cannot help but recount some of the arguments that the petitioners were.
I would not like you to use the word warring faction. I would not like you to use the word warring faction. I would say they have made allegations of corruption, and these allegations may look like war against each other, but sensible people should look at it as serious allegations made, and the government, having an overview, decides to inquire into it. Shouldn't they inquire into it?
Mr. Sen.
So it should not be
Mr.
used
Sen.
as
So serious charges, not
on.
calling it a warring faction, let's call it trading of serious charges. But Ms. Bhati, let me come back to you again, recounting some of the arguments that the petitioners had made. What they're essentially arguing is that a fixed term is essential for the CBI director to ensure institutional integrity, to ensure that the independence of the CBI is maintained. With that in mind, any suggestion, any move towards perhaps even relieving the Director of Active Duty, would that not again require the consent of the selection panel? Again, they are the three of them, the Prime Minister, the NOP as well as the CGI. They are the supreme authority in terms of vetting the candidates, in terms of selecting the candidates. Would their consent perhaps in principle also not be required? There has been no reference made even to a consultation with this panel. So is that not a blinding error perhaps on part of the CVC? Ms. Bhati.
Well, Ashmit, if you're asking for my views, I am clearly of the view that, the manner in which things have happened, there was, it's not that somebody has been removed from the post. Had it been, now a protection of tenure is a very important feature, and that is what is come out of the Supreme Court judgment also. But the protection of tenure is in the normal circumstances. It does not mean that, you can't extend it to mean that if somebody is indulging into, okay, here the allegations are of corruption. Had these important people, indulged in some criminal activities, would it still be that they would be immune? That kind of immunity is not available under the rule of law. In fact, I must tell you that here this tenure protection is under Supreme Court orders. The Constitution protects the tenure of High Court and Supreme Court judges in our system. But now, Mr. Sen also gave an example. Then it's replete with examples. Of course, extraordinary situation where even judges whose tenure is constitutionally protected, they have been relieved of judicial work. All work is taken away. Justice Karnan's example is not too far away. So he was a sitting High Court judge when all that happened. So the work was completely taken away from him. So relieving of duties in the face of such serious allegations during the pendency of investigation is how we should see it. And I also don't see any harm in Supreme Court looking at it. It is fine. Investigation maybe could have happened before. Then also the matter would have come to Supreme Court. And I think it's better that Supreme Court is dealing with it now so that, there will be no questions raised.
Right, so the Supreme Court is dealing with it, but the last word is yet to be said. The Supreme Court will be taking up this matter for further consultation and hearing on December 5th. That's when, of course, we can expect clarity on whether or not Alok Verma is to be reinstated, or perhaps the CVC prayer could be considered for further time for investigation of charges against Alok Verma. So all doors are open. More clarity on December 5th. Ms. Aishwarya Bhati, Mr. Shantanu Sen, appreciate you joining us on CNBC TV 18.